Hear ye, hear ye, hear ye. All present have anything to do for the Honorable Justice of the Appeals Court, now sitting in the Boston Appeals for the Commonwealth. Draw near, give your attendance, you shall be heard. God save the Commonwealth of Massachusetts. Court is now open. Please be seated.
Good morning, everyone, and welcome to the Massachusetts Appeals Court. I am Chief Justice Amy Blake. I am joined today to my right by Justice Joseph Ditkoff and to my left by Justice Robert Brennan. We are the panel that will hear the 6 cases that are before us today. I know most of you have been here before, but just a couple of things to remember. Each side is permitted 15 minutes of argument. There is no rebuttal. We have read all of your papers, so you should get right to your argument. After the first 3 cases, we are likely to take a brief morning recess just so you can plan your morning. With that, I will call the first case on the list today, which is Frank Hennessey and another versus Revolve Realty Development, LLC, docket number 24P516. Counsel, good morning.
Good morning, Your Honors. If it please the Court, my name is Michael Magro, and I represent the defendant appellants in this case, Revolve Realty Development, LLC, Madeline Castor and Anthony Yeba. Your Honors, this case presents 2 issues before the Court. The first issue is an error of law made by the motion judge on a Mass Rules of Civil Procedure Rule 12C motion for judgment on the pleadings, which then carried through every dispositive pleading that followed and prevented the defendant Revolve Realty from asserting defenses and counterclaims. The second issue before the Court is a motion judge having made a clear and procedural order that was then ignored by another motion judge, which had the same chilling effect on Revolve Realty's defenses and counterclaims. The primary issue pursuant to the Rule 12C motion was whether the plaintiff Hennessey had a duty to disclose information beyond that which they had already voluntarily disclosed to Revolve Realty. Pursuant to ample Massachusetts case law citing to the Restatement Second of Tort, Section 551, a duty to disclose arises when, quote, there are matters known to the speaker that he knows to be necessary to prevent his partial or ambiguous statement of the facts from being misleading, end quote, or the non-disclosed fact is basic to or goes to the essence of the transaction. There's a third prong to that or test, which is where there's a fiduciary duty, which obviously doesn't apply here. The law in Massachusetts is equally clear that the law abhors fraudulent conduct to such an extent that a party will not be charged for failing to discover the truth for a lack of diligence, provided that their reliance is not based on preposterous or palpably false representation.
What do you say the fraud is?
Excuse me, Your Honor?
What do you say the fraud is?
So the fraud, Your Honor, was the voluntary representations made by the Hennesseys, which was that they had a quick sale and that there were no contingencies, that it was a cash deal.
But where's that in your complaint? Where does your complaint say no contingencies, it's a quick sale?
In the purchase and sale agreement, Your Honor?
It was dismissed for lack of specificity on the fraud. Where in your complaint did you allege that anyone said that?
So, Your Honor, I'm the defendant, so I would have filed in response to the 12C motion.
In your counter complaint.
So, Your Honor, in the original answer and in the original response to the 12C motion, I don't think there's any doubt, Your Honor.
No. We decide motions for judgment on the pleadings based on the pleadings. So where in your pleading did you allege that anyone said any of those things?
So, Your Honor, it's in both the answer and it's in both the opposition to the Rule 12C motion. And
so you're telling me it's not in the complaint. Is that what you're trying to tell me?
Well, Your Honor, again, I wouldn't have filed the complaint. The
counter complaint. You filed the counter complaint. A judge found that you didn't allege the fraud with specificity. So where in your counter complaint are any of these statements?
So, Your Honor, in the counterclaim is replete with more than sufficient information in order to establish the allegations of the tort of nondisclosure or fraudulent omission. It goes through what the actual voluntary disclosures that were made by the Hennesseys. It then goes through.
And those are what? I read, was already under agreement, was closing soon, and that their buyer was paying cash.
Correct. And there was no mortgage contingency. Those were the sole voluntary disclosures made by the Hennesseys. What the Hennesseys did not disclose, Your Honor, is a second is the presence or the existence of a second contingency, which is that the purchase and sale agreement for the Hennessy's buyer, for the Hennessy sale of 8 Twin Post Road, was also subject to their buyer selling a $14 million marijuana business in California, which the Hennessys failed to disclose, which was more than a material fact. I think, Your Honor, if you...
Can I just stop you? What's your best case that says that they had a duty to disclose that information?
So the best case that they had a duty to disclose, Your Honor, is when you look at, Your Honor...
Best legal case. Best actual case.
Actual case.
Yeah,
so, Your Honor,
from law that tells me that is, in fact, a duty.
So, Your Honor, there's a litany of cases that tell you that that's a duty. You can look at York versus Taylor to begin with. Yep. You can look at Canavos versus Anino, Snyder versus Berry Hutchison, VSH Realty versus Texaco. There's 2 or 3 other cases I can cite to you. What those cases...
York, if I'm not mistaken, and correct me if I'm wrong on the facts, that really had more to do with, that had a sale of a property and there was some fundamental issue with the property, right?
Correct, Your Honor.
Basic, again, if we go back to the language, basic to the transaction. So how was this information basic to the transaction between these 2 parties?
So, Your Honor, what's basic to the transaction here, what's clearly basic or essential to the transaction even, Your Honor, as the cases talk about, is the fact that we have the Hennessys that made this voluntary disclosure, this voluntary partial disclosure, this misstatement, these half-truths to Revolve Realty. They did that in order to obtain Rider A, Paragraph W, which is the clause that allows them to terminate the P&S if their sale doesn't go through. That was so important to them, Your Honor, that they presented these half-truths and these misstatements.
Now, again, the misstatements and half-truths are already under agreement, closing soon, their buyer was paying cash.
Those were the misstatements and half-truths, Your Honor, in addition to the fact that the Hennessys failed to disclose that their purchase and sale agreement with their buyer was subject to the sale of a $14 million marijuana business.
Not to jump on Justice Ditkoff's question, but which of those was an untruth? Under agreement, that was true, right?
So, Your Honor...
Let me just take it one at a time. Under agreement, was it true?
Yes, Your Honor, that's true.
Closing soon. Well,
No, Your Honor, that was not true. That was not a true statement, Your Honor. And the reason why that was
paying
not...
cash. I mean, the contingent on...
No mortgage contingency, Your Honor, it was a true statement. It was not true that it was closing soon.
Hang on. No, where does it say no mortgage contingency?
Well, that's effectively what it means when it's a cash transaction. It's saying that there's no mortgage contingency. And in fact, Your Honor, if you look at the purchase and sale agreement for 8 Twin Post Road, there is no mortgage contingency. Yep. But to answer you, to go back to your question, Your Honor, because it was an important question. So where I left off was it was important enough, Rider A, Paragraph W, that the Hennessys would not have entered into the purchase and sale agreement without it. Whereas if you look at Revolve, had Revolve known that the sale of the Hennessy's house was subject to a $14 million sale of a marijuana business, the Revolve Realty wouldn't have entered into the purchase and sale agreement. I can't think of anything, Your Honor, that goes more direct to the essence or the basis of a transaction than that neither party would have entered the agreement if they had known what the other party was doing or saying. To answer your other question, Your Honor, that you just asked about what was false about you asked about closing soon. Well, Your Honor, if you look at the record and you go through the record, in fact, the record is replete with the Hennessys not even knowing when the closing was to occur. In theory, the purchase and sale agreement had a January 19th closing date, which effectively was kicked to the 22nd of 2019 because of a holiday. You see email after email after email, Your Honor, in the record. You can go back to Volume 2, page 219, page 226, page 234, page 246. It goes on and on where the Hennessys are asking all these questions. Has anybody seen the purchase and sale agreement for the sale of the marijuana business? When is the marijuana business going to close? Effectively, Your Honor, the contingency for the marijuana business ran right up to the date of closing under the Hennessy's purchase and sale agreement for the sale of their house. So effectively, the Hennessys never knew whether or not it was a quick sale. They never knew it was a sale at all until the marijuana business had sold and they were given notice.
Let me ask you this, counsel. You say that the whole obligation was on the Hennessys, but what comes out in discovery, and as I understand it, your client accepted the offer in 24 hours without any investigation. They actually asked to move up the P&S date, and text messages, at least in the addendum, suggests that your client had a reason to get this P&S signed and done because they had another pressing issue, i.e. a forbearance from the lender on their mortgage. It seems to me that Revolve might have gone into this with their eyes closed intentionally because they were working some other deal on the other end. And now, you're looking to run away from whatever responsibility Revolve had in where we ended up.
So, Your Honor, you asked me
Your
you asked me two questions there. I'm going to take the second question first. The second question first, I believe the answer is abundantly easy because the case law in Massachusetts is abundant. It's extensive. It goes back, I believe it might even go back 100 years, Your Honor, that, for example, the quote from Canavos, where nevertheless, where there is reliance on fraudulent representations or upon statements and actions treated as fraudulent, our cases have not barred plaintiffs from recovery merely because they did not use due diligence when they could readily have ascertained from records what the true facts were.
That presumes that it was fraudulent. What if we conclude that it wasn't fraudulent?
It doesn't matter, Your Honor. The case law, again, is abundantly clear that even in the case, and that goes to the, so for example, Your Honor, you can look at the York versus Taylor case. Well, York versus Taylor is a case where the court found and the appeals court agreed that the seller did not act in a fraudulent manner. The seller had misrepresented the assessment.
You're saying that if Revolve has unclean hands here, it's immaterial to our analysis.
Okay, so, Your Honor, Revolve does, with all due respect, Your Honor, Revolve does not have unclean hands here.
I'm asking you a hypothetical. If Revolve has unclean hands, is that immaterial to our analysis?
Your Honor, answering that hypothetical question, no, because I would believe equity would trump. But if I understand your question correctly, Your Honor, you're asking me about, or you made the statement that Revolve may have unclean hands because of the text messages. But, Your Honor, let's put the text messages in context. The text messages, when they were viewed by the court in the motion for summary judgment in July of 2023, Your Honor, those text messages were in the context of my client having already lost any defenses in their counterclaim with regard to nondisclosure and with regard to fraudulent omission. Hypothetically, Your Honor, as your question is asking, how would those text messages possibly have been looked at if, in fact, my client had the benefit of the defense of nondisclosure and had its counterclaim for nondisclosure and fraud in the omission? And I think, Your Honor, the answer to that question is those text messages very easily could have been looked at very different. The other interesting part of those text messages that I'd like to point out to the court is also there's a text message, Your Honor. So the problem with the text messages that the motion judge had with regard to was with regard to what my client said, freaking people, and why should we give them any money and things like that. It was taken in a negative connotation. However, Your Honor, I can take you back in the record to Volume 2, page 259. There's an email on January 5th from the Hennessey's counsel, where he writes to Attorney David, who's the counsel for the Hennessey buyer. He says, quote, "Any news will be much appreciated, whatever you have some. I have a real asshole for a seller's attorney on the other end of this deal." So, Your Honor, what's different between that statement and the statement that my clients are being held negatively responsible for the statements that they made in the text messages? So I would submit to the court, if those text messages are put in the context where my clients have an active non-disclosure fraudulent omission argument and actually have that before the court and can argue it, those text messages very easily, by a finder of fact, could be interpreted in a completely opposite direction.
Here's what I don't get. If there's fraud in the inducement, all the cases say the remedy is rescission of the contract, which would still result in the deposit being returned. Why would fraud in the inducement for the contract mean you get to keep the money?
Because Your Honor, it would be at the very least, it's a breach, the argument's a breach of contract, and the other counts that I asserted in the amended counterclaim that was never allowed. It would be because, Your Honor, that that would be the only measure of damages because the purchase and sale agreement with the Hennesseys has a liquidated damages provision. That would be my client's only recovery. That would be the recovery, even though there would be rescission of the contract.
Why, if the contract's rescinded, isn't the liquidated damages provision rescinded too?
I would submit to the court, no, it's not. because that would be my client's damages for having taken the property off the market for upwards of 60 days based on a misrepresentation made by the Hennesseys. However, Your Honor, with regard to the issue before the court, though, that may be an issue further down the road. I think the issue before the court today is the application of 551, especially 551, the second prong of that, where it talks about where the matters are known to the speaker, and he knows to be necessary to prevent his partial or ambiguous statement of the facts from being misleading. I think that's the issue before the court, and I think that's the issue that requires the court to vacate the judgments.
Before we run out of time, which is coming up soon, can we agree at least that there's a difference between repleading a case and amending a complaint?
If I understand your question, Your Honor, and I think it goes to the motion for reconsideration. Yeah. I think that the interesting issue with that, Your Honor, is you have Judge Wilson, when he dismissed the last of the counterclaims of Revolve Realty, he specifically says this is not a motion for reconsideration. This is a motion that can go before any judge. And he actually issues a second order to clarify what he said, where he says, I misspoke when I said this should go back to Judge Miller. This can go to any judge, and I direct the clerk of court to submit this motion when it comes into any judge. So I think based on that fact alone, Your Honor, you have the issue where I bring up of the law of the case doctrine, where Judge Wilson had clearly resolved that point, and it clearly said this is not a motion for reconsideration. The path forward that Judge Wilson set that should have been followed was that I was given leave to amend the counterclaim. It should have been heard by a judge, and under Rule 15C, as the court knows, liberal pleading standards, they look for people to get their day in court, and I firmly believe the motion to amend would have been allowed, Your Honor.
And we will have to leave it there. Thank you very much.
Thank
Attorney
you, thank you, Your
Fenn.
Honors.
Good morning, Your Honors.
Good morning.
I'm Peter Fenn, representing the Hennesseys. May it please the court. Your Honors, I'd just like to introduce my client, Frank Hennessey, is here with his daughter, Christina, sitting in the gallery. She has never been in a courtroom before and asked to come this morning, and I'd like to introduce them to the court. Your Honor, Your Honors, two things I'd like to correct right off the bat. The statement that was made was not under agreement closing soon cash buyer. If you read the email from Jay Donahue to Elena Price, it says, under agreement, P&S signed cash buyer. The shibboleth of closing soon is an artifact.
Well, but for a judgment on the pleadings, don't we have to go by the counter complaint, not
Absolutely.
the...
And Judge Miller took that as true for the purposes of a Rule 12 motion, but I just want to call to the attention of the court that it's not true.
I get it.
It's been said again and again. The reference to it in the briefs of appellant are to their own pleadings, not to any independent verification. There were two motions for summary judgment, well supported by statements of material fact with citations to the record, to documents, and to testimony. Nowhere does that representation actually get made. And in fact, it's absurd to think it would have been made because the Hennessey signed the purchase and sale to sell their house first with a closing date of January 18th. And then they signed a purchase and sale to buy the next property with a closing date of January 19th, not realizing that was a Saturday, so it got pushed to Tuesday. They were always coordinated. There would have been no reason to tell anybody it was closing soon. I think what happened was some facts got conflated. The Hennesseys were told by their buyer that his sale of assets was closing soon. But in fact, they kept telling us tomorrow, tomorrow, tomorrow. And maybe somewhere along the way, someone said closing soon, and it got conflated.
What about the statement about, oh, you know, the kids are home for the holidays?
No support in the record. I believe the Hennesseys may have agreed to sell their house in mid-January because they wanted to have that time, and then they offered to buy another house the same way. But they never made that representation to Revolve that they wanted to push it. They never asked for a continued date. They made an offer that had a date of closing in it. No representations whatsoever. The only representation that was ever made prior to the offer or at any other time was under agreement, signed P&S, cash buyer. That's it. One other thing I want to correct was you asked about the text message and the timing, and counsel attempted to put them in some kind of context. That's false. The text messages were exchanged the day the offer was received by Revolve's principals. It's simultaneous. There was nothing about having lost their counterclaim or anything else. They got the offer. They said, there's a contingency. That's not good for us, but wait a minute, there's no more contingency, and they rapidly accepted the offer because they were under the gun to have something to show their bank. Having disposed of those two issues, I'd like to move to the second issue on appeal, which is Judge Miller's decision, which was essentially confirmed by 4 other judges of the Superior Court. By my count, this is the 7th time Revolve has attempted to put its alleged fraud claims before a court of this Commonwealth. Before Judge Miller, before Judge Wilson, before Judge Connolly twice, before Judge Layton, and again, finally, in front of Judge Davis. And every one of them, although not required to, actually considered these claims on the merits. They didn't need to, but if you look at Judge Connolly, who denied the motion to amend because there was nothing to amend, she later decided the motion for summary judgment, where the same fraud claims were interposed as a defense to the Hennessy's contract summary judgment claim. And in her decision, she said, they've raised these fraud claims again and again. They've raised them before me now. They have no merit. They're not supported by fact or law. She didn't just say, and by the way, these have been dismissed by Judge Miller, and I'm relying on that as law of the case. She said, independently, they are not supported by facts or law. The other judges did the same thing. Judge Wilson.
Your view that the Hennessys had no obligation whatsoever to disclose that their transaction was dependent upon the sale of this business in California?
None whatsoever. It's an unrelated transaction. They disclosed they had to sell in order to buy. They disclosed more than people sometimes disclose, which is that their buyer had no mortgage contingency. The source of his cash, the source of his funds, is immaterial. It's simply not part of the transaction. It can hardly be said to be basic. Looking at the law of fraud, and there are very few cases on partial disclosure, partial truthful disclosure leading to an obligation. But throughout the cases on fraud, on misrepresentation, 3 things are abundantly clear. First is that there has to be a statement, truthful or false, there has to be a statement. Secondly, it has to mislead the hearer. You can make all the statements in the world, and if they know they're not true, it doesn't matter. People puff all the time when they're selling real estate. It has to actually mislead the hearer to their detriment. It has to make them believe something that's not true. What was not true here? Nothing. They said, our house is under agreement, P&S is signed, cash sale. What was that going to make Revolve believe that wasn't true? Nothing. This simply, and beyond that, there's nothing in the record that showed they relied on this statement in any particular way to their detriment. They wanted to sell their house. They accepted an offer subject to a contingency, which is typical. The Hennessys also had a contingency, which is typical. All of these contingencies ran up to the date of the closing. The contingency for the purchase of Twin Post Road by Mr. Hedaya said, I've got to sell my business, and he had the right up to the day of the closing, if his business had not sold, to rescind that deal. Having that in hand, the Hennessys made an offer with coterminous terms. They wouldn't say, we're gonna waive our contingency sooner than our buyer has waived his because they can't close.
Would it be different then if Revolve was not sort of a sophisticated player in this equation, if it was just, you know, Joe and John Smith selling their property, whereas Revolve is a specialized entity?
I think every case is dependent on specific facts. Conceivably, it could be different. I don't think it would be if you look at Swinton. A buyer is not required to do the seller's due diligence for him. The seller's, obviously, and my brother is right, that if something is unfairly concealed and you don't necessarily are not held to a standard of having failed to do due diligence. But you don't have to independently do that for him to tell him everything. As Swinton said, if the buyer had to tell a seller everything about their property that might be wrong with it, we'd never have an end to it. The buyer does not have to say to certainly to a sophisticated seller. We have people who've been in the real estate business. One of them is a real estate agent and a builder. They've built and sold many houses. We didn't have to tell them how to do due diligence on a contingency. They know. They chose not to. If it were 2 parties who were in pari delicto, on equal footing, Maybe, but I don't think so. I don't think you have to go behind your deal to the deal that's behind that deal and talk about it to your seller. And I note, by the way, that virtue of that exception, all of the cases in this field have a buyer suing a seller for misrepresentation. I haven't found any others where a seller is suing a buyer for misrepresentation. It doesn't happen.
To follow up on the Chief's question.
I'm sorry, on the...
To follow up on the Chief's question, saying something like it's under agreement might mean something different to a sophisticated real estate player versus someone who's buying their first house, don't you think?
Certainly. But both parties here were represented by experienced brokers. Matter of fact, all communications went to the brokers. The parties never spoke or communicated, never met. They both had sophisticated lawyers before the purchase and sale agreement was signed. I could tell you what the Hennesseys did before they accepted Hadiah's offer, which they asked Hadiah's lawyer to see the asset purchase agreement for the assets he was selling and to see the financing commitment for his buyer. They did some due diligence, even as residential unsophisticated buyers. Their lawyer did due diligence that the other side never did. All it would have taken was said, send me a copy of the P&S, and it would have been sent. As Judge Brown said, the stage is lit, the actors are there. If they choose not to see the play, that's their problem. They chose not to see the play. I don't think in these circumstances, and I think the courts, so far 5 judges of the Superior Court, and I hope this court, will agree that in these circumstances, the Hennesseys made no false statements. Their half-truth, as it's called, was not intended to deceive anyone. No one was deceived. They knew, as counsel conceded today, what cash deal meant. And they had no reasonable right to rely on that to mean no contingencies and this will absolutely close. Everyone in the business knows that when there's a contingency, sometimes deals don't close. This one didn't.
So two hopefully quick questions. One, you're basically seeking fees because 93A requires us to address fees, right?
Absolutely.
Okay. Second question is, can you briefly address the denial of the motion to amend?
Sure. There are 2 things I'd like to say about that. The first is I think Judge Connolly was not bound by anything that Judge Wilson might have said. What he said was, this could go to the session judge in the ordinary course and she'll decide it. He's given them leave to file a motion to amend. He hasn't pre-ruled on that motion, which had not yet been filed. When it got to Judge Connolly, she looked at the 3rd iteration of the counterclaim and said, there are no new facts here which would warrant considering this.
So it was futile.
It was futile. The only 2 new facts in that complaint were they alleged that the Twin Post Road purchase and sale had never been signed, therefore the Hennesseys didn't have a deal. That was not true, and a copy of the signed P&S is in the record. And the second thing they proffered was some emails from Frank Hennessey to his broker saying, I'm nervous about whether this deal's going to close. Of course he was nervous. Every buyer's nervous when there's a buy-sell. That's not fraud. He was nervous the day he signed the offer. He's nervous the day he signed the P&S. He's probably nervous today. That's not fraud. So in the first instance, she's correct in saying there's no live counterclaim to amend. This should be brought as a motion to replead. It's sort of a distinction. But she also looked at then and again when she decided the summary judgment motion on contract, she looked at the merits of the fraud claim and found them lacking, as had Judge Wilson, as had Judge Miller, as Judge Layton did later when they were interposed as a defense to the summary judgment motion on 93A, and as Judge Davis did when he heard the assessor damages. And he actually held an evidentiary hearing over 2 days, heard from both principals, heard them tell him why they thought they'd been defrauded. And I quote what he wrote, this court's not buying it, and neither should this court. Under these circumstances, the minimal interaction between the brokers as they're trying to massage a deal into place, and brokers talk all the time. And earlier in the process, the Hennesseys' broker had talked to their broker before the Hennesseys' house was under agreement, said they might be interested, and she basically said, until their house is sold, don't bother. And when his house was sold, he got back in touch with her. He said, it's sold. It's under agreement. P&S is signed. We have a cash buyer. We're going to present an offer. That's normal broker speak. That doesn't require the buyer or their agents to say, and by the way, our cash buyer is selling some assets, and we've looked at the purchaser of those assets, and he's got an asset purchase agreement, and we've looked at his financing, he's got a commitment for finance. If they want to know that, they got to ask. There's no obligation independently to start going into the deal behind the deal. And that's what they're seeking. If this court were to rule for Revolve here, it's a depth charge in a conveyancing practice. Where does it end? Does a buyer have to say to the seller, this is a really good deal, I think your house is worth more? Maybe you shouldn't sell to me for this price. Maybe you should look at some comps. So the buyers say, you know, by the way, I saw my cardiologist last week and I've got a...
Isn't a depth charge something that only affects submarines in a particular space?
It's perhaps trying to highlight the amount of confusion that would result from such a ruling. I think what Revolve is asking this court to do is change the law of disclosure, to require disclosure when there's no actual misstatement that causes a false belief that is relied upon. All they say is you make a statement, you got to make more and more and more. That's not the law, and it shouldn't be. You know?
Just see if there are any other questions from the panel. I don't see any. I think we have your argument, and the matter will be under advisement. Thank you all.
Thank the court for your time.
Our next case is Peter Lannon versus James Lannon and another, docket number 24P794. Chief, are we missing a lawyer? On the Lannon case, do we have counsel?
Yes, Your Honor, for the plaintiff,
Yeah, we're
Peter
missing
Lannon.
some, okay.
Good morning.
Counsel, I'm going to ask you to put your cup on the floor. You're welcome to use our cups and water. Counsel, when you're ready.
May it please the court, Your Honor. My name is Sean Sullivan. I represent the plaintiff appellant, Peter Lannon. The key issue on appeal here is whether or not the trial court clearly erred in finding that Peter Lannon holds the 150 Atwell Circle property as a constructive trustee for the benefit of the defendant, his adult son, James Lannon, and his son's girlfriend, Jamie Patz. We're asking that this court reverse the findings and judgment of the housing court. This case, as you know, was filed as a summary process action in the housing court. Mr. Lannon was seeking only to establish possession back of the property after a series of disputes with his son and his son's girlfriend.
Here's the trouble that I have. You know, we're not looking at this de novo. So we have a judge who has made credibility findings, and to put a fine point on it, he didn't believe your client. So what do we do with that?
Well, Your Honor, the findings that the judge made in the decision that allegedly my client said at trial are not in the record. He characterizes that Mr. Lannon said the $130,000 down payment was a loan. If you review the trial record, there is not a single, the word loan is never mentioned in the trial record at all. He weighed the credibility against my client based on that statement, according to the decision, and favored the testimony of my client's soon-to-be ex-wife. They have a pending divorce going on right now.
Can you say that again? Did you say that the judge found that the $130,000 was a loan, not a gift?
He found that my client, Mr. Peter Lannon, testified that it was a loan.
All right, but regardless of that, he did find that it was a gift.
He did find it was a gift, which is our position was clearly erroneous.
Understood.
Because there was...
Okay, and that's my question. How do we get to clearly erroneous on the record that we have before us?
Absolutely, Your Honor. I'm happy to address that.
The judge credits the wife's testimony and the son's testimony and the girlfriend's testimony, if you will.
Well, if you look at the facts, this house was purchased in 2016 for $342,000. The written documents in this case would be that my client's name is the only name on the deed. He's the only name on the mortgage. The only other written document that bears on the disposition of this property was the amended 2018 will of Barbara Lannon. So that means 2 years after the purchase of the property, 2016 to 2018, both Peter and his estranged wife, well, at the time they were living together in their marital home, they then amended their wills,
So can I gently stop you there? Because
Absolutely.
it doesn't have to be marriage. Anybody's in a partnership. You have people, we have 3 cars in my family. All 3 of them happen to be my wife's name. Does that mean I don't have any rights over any of the cars at all, and that they're 100% hers? Or if we buy a piece of property and for a variety of reasons we say, you know what, your credit right now is a little better. Why don't we put your name on the property because mine might drag us down?
No, and
Does that mean that I'm out completely?
No, and that's not what our position is, and I'm happy you brought that up, because at all points in time, the court found, and my sister has argued, that my client is seeking to establish sole legal title to this property. That's not what my client has ever sought. We sought a summary process action seeking possession, because my client was also living there with the defendants at a point in time. We were not seeking sole title. At all points in time, Mr. Lannon testified that this was a purchase of joint marital assets for he and his wife, for his son and his son's girlfriend to live in and rent and pay a modest amount of money to Mr. Lannon. That was the end and the nature of the transaction, and that's reflected in this amended will of Barbara Lannon. 2 years later, they update Barbara updates her will, and it says, if she dies and Peter is still living, Peter inherits the full estate. 150 Atwell specifically mentioned in that amended will.
So I know this isn't the legal question before us, but sometimes I just can't take my probate and family court hat off. And would this purported amended will pass muster if it was probated? Handwritten interlineations like this that were not recodified with a witness?
Certainly not on the handwritten changes that...
So the judge considers it as, to me, whether it was a will or some other document, it's some statement of intent, right? I don't think it carries the day. It doesn't have the legal force of a will. But then the wife gets on the stand and says, yeah, but this is what I was thinking, and the judge credits that, even in the face of this written instrument, whatever legal effect it has. Doesn't he get to do that?
Yes, you're correct, Your Honor, he does. But the issue is that everything the defendants have alleged in this case is based on oral conversations. The one document in this case that is this will. So it's the only document written that deals with the disposition and ownership of this property. And 2 years after the purchase, they still considered it to be marital property.
Right, so we can all read into it that Peter and his wife's marriage is going south, and she's now aligned with the son, and she's changed her position. And if we were hearing this case de novo, we might completely agree with you, right? We can sort of see what might have been going on in the background here in this family. But ultimately, Judge Michaud made the findings he made, even in the face of this written document. So if we are bound by those findings, which I believe we are, except to some that may be clearly erroneous, the question for us is a legal question about whether or not this constitutes a constructive trust. And I do think he took a little field trip on the fiduciary relationship piece. So let's put that aside. In all other respects, if we accept his findings and we exclude the erroneous finding that you've identified about what your client testified to, this meets the statutory definition of a constructive trust.
Well, Your Honor, there's multiple other erroneous findings that the judge made that I'm happy to address. And respectfully, I disagree that it would meet the criteria for constructive trust, because Massachusetts does not typically recognize fiduciary relationships amongst family members without more in other circumstances. And those other circumstances are in the context of when there's an accountant, a lawyer, an investment broker, someone who is in a superior position. That's the Hawks v. Lackey case, where someone is in a position of higher knowledge.
I don't understand why that matters. If this property was a gift, then there's a constructive trust regardless of whether there's some other fiduciary relationship, right?
I'm not sure I've understood your question. If
this property belonged to James from the beginning because the down payment was a gift, then it doesn't matter whether there's some separate fiduciary duty. It's a constructive trust, right?
Well, I think there's two separate components to it. I think it's a matter of, was the $130,000 a gift? But the judge isn't saying that the home was a gift. He's saying that the home was.
Well, if all the money that goes towards this house is either a gift to James or James pays it, then doesn't that show it was the intention that it be his property?
If the funds were ever transferred, but for there to be a gift, there has to be donative intent and there has to be actual constructive delivery. The funds never left the marital estate.
I think they went to the seller, right?
They went to the seller.
So they left the marital estate.
Let me correct that. When I said they didn't leave the marital estate, I meant they didn't leave the marital estate and get transferred directly to James and Jamie Patz.
Well, I just went on Amazon a few days ago, and I ordered a wallet for my son. And I gave the money directly to Amazon, and they gave the wallet to my son. That's not a gift to my son because I didn't give the money to him first?
Well, it's a gift because you intended it to be a gift.
Which
But
the
if
testimony here is that this
right.
was intended to be a gift, right?
That is what the judge is finding, that he believed it was intended to be a gift. And as I was going to address with the other findings, it appears that the findings were clearly erroneous with respect to the gift. And if there was no gift, then there would be no constructive trust because post-conveyance.
I think you're about to. Can you identify specifically which findings support that argument?
Absolutely, Your Honor. So Mr. Lannon, James Lannon, testified that he and Jamie believed that they owned the house, and at the right time, he would purchase the premises from Peter for the outstanding balance of the mortgage. There's nothing in the record to ever reflect when this further time was going to occur with respect to when they were going to purchase it. But I want to get to another point briefly, I'm sorry. Well, on the credibility component of the judge's findings, it was that because Peter Lannon testified that this money was a loan, and the judge found that there was no loan agreement, there was no documents, no written contract reflecting the loan, he substantially weighed that against Peter Lannon and said, because there was no loan documentation, the testimony of Barbara Lannon, James Lannon, Jamie Patz was credible in that the oral conversation about there being a gift was, in fact, what the transaction was. That's the...
So I'm just reading that you're saying that the, I'm sorry, go ahead.
That's okay. That's my point on the gift component of this.
Okay.
Can we talk about the unjust enrichment piece? Because
Yes.
if we were to agree with you that there was not a constructive trust created here, what would you say that James and Jamie are entitled to for the improvements and changes that they made to the property? Are you saying that they get zero?
No, that's not what I'm saying. I think that everyone should get what is equitably theirs. And Mr. Lannon, again, the heart of constructive trust is to avoid unjust enrichment. Mm-hmm. Mr. Lannon, Peter Lannon, is not seeking to be unjustly enriched. He's not seeking sole legal title. He's not trying to go sell the property. He and his wife are getting divorced. The court had this as if my client is some multimillionaire and he took this money and just, bought this down, put this down payment down for his son. My client has nowhere to live. He's living still with a friend to this day. He's 75 years old now. This wasn't just, extra cash they had floating around. Him and Mrs. Lannon have one marital home, and that's down the road from this 150 Apple Circle property. Mr. Lannon was living, after him and his wife decided to separate in 2021, he was living at the 150 Apple property with his son and his son's girlfriend. Since, he's entangled with this mortgage. His name, he's the only sole person on the mortgage. He's the only person on the deed. And what sparked this whole case was that the defendant stopped paying him rent, use and occupancy rent, however we want to classify the monthly obligation they had to Peter Lannon. They stopped paying that to him over dispute over the placement of a basketball court in wetlands. So on the unjust enrichment component of this case, all that would result, if what we had alleged and what we advanced at trial were to come and have the judge ruled in our favor, the title would have remained the marital asset, even though, to your point, Peter Lannon's the sole name on the deed and he's the sole person on the mortgage. It still is a marital asset. We've never said that it's not. We've never tried to take it out of the marital estate. Mrs. Lannon, Barbara Lannon, in fact, has, and that is an issue with her credibility at trial. She's highly motivated, as you can see from her handwritten changes to that 2018 will, to deprive Peter of the marital asset. She wants to move it out, give it to the kids, well, to her son and apparently now to his son's girlfriend. And what my client is saying, that this property is part of the marital estate. In the equitable division of the marital estate, everyone gets their fair equity in the property. However, Barbara Lannon and Peter Lannon, if he has a change of heart as to what he wants to do with the gifts and the future intent of their estate plan, they can do that. As far as the equitable distribution of the improvements to the home, I agree that everyone should get what's fairly theirs. I don't think that anyone should be deprived of that. My clients never said that anyone should be deprived of that. No one at trial put in documents to support what they did for improvements. Everyone testified that they had done some different improvements. Some of it was done by manual labor through the skills of James Lannon. Other things were paid for by my client. No one put in documents to reflect that. This was a summary process trial. I mean, this was something where initially, and I understand that the housing court has equitable jurisdiction to rule over this, but there was no depositions allowed in this case. This was something that, the word constructive trust got brought up in the counterclaim, and it was tried, but otherwise this was a summary process case seeking to restore possession after my client was physically assaulted by his son, and that's what led to us serving a 30-day notice to quit. My client had to get back into the house he was living in. That was the heart of this case. This wasn't about title to the property. 7 years had gone by since they purchased this property. 7 years. Never once was there a text message, any written correspondence, anything reflecting, hey, it's the right time to purchase this house back from Dad. There was nothing, the rates had dropped obviously during COVID. There were so many circumstances that could have resulted in them turning around and saying, it's time that we purchase this property from Dad, is allegedly that was the agreement. Though the statute of frauds would govern that. If what they testified was true, that at some point in time down the road, they were going to repurchase the property from, that would be governed by the statute of frauds, as would everything else in this case.
Let me just check to see if the panel has any other questions. They do not, so we're going to have to leave it there. I'll take the rest of your arguments on your brief. Thank you so much.
Thank you very much, Your Honors. Thank you.
Attorney Maglione, if I've pronounced that correctly?
Maglione.
Maglione?
Good morning. May it please the court. My name is Christine Maglione, and I represent the appellees James Lannon and Jamie Patz. As we've been discussing, this case arises from a dispute over the beneficial ownership of the property located at 150 Atwell Circle in Marshfield, Massachusetts. The property was purchased in February 2016 for $342,000 with a down payment of approximately $130,000.
I think most of that is uncontested, so I'd kind of like to get into the meat if we could.
Yep.
Mr. Sullivan points out some areas that it appears there may be some clearly erroneous findings that this judge made. If we were to excise those from his decision, is there sufficient record to stand a constructive trust up on this record?
Absolutely, Your Honor. No question that those references to a loan are in sort of the summary fashion or portion of the judge's decision. But the judge is it's very clear at the end. I'm sorry.
I don't know about that, right? It's a very long decision, and it's entitled Findings, Rulings, and Order. So they're all findings, rulings, and order, so they're all in. And there do seem to be some things that might have been paraphrased or summarized in some way that I didn't find record support for. So what do we do about that?
I agree that the references to the loan aren't supported, and I addressed that in my brief in terms of that's not dispositive of and anything of significance to the finding of a constructive trust, where there was a gift of the down payment, which The court credited the testimony of Barbara LANNON, James LANNON, and Jamie Patz on that specific issue, and specifically rejected the testimony of Peter LANNON and whether or not it was an investment. And I think the court had referenced it in a way of the basis for the down payment or the reason for the down payment. He rejected it. So regardless, he didn't believe him on that point. So we have like this consideration basically to support that there was a gift. And then we get to whether or not there was a constructive trust, because he then on his own, Peter had suggested that the parties put the title of the property in his name in order to secure a better finance loan for James and Jamie. Again, asserting his superior financial acumen.
But is the evidence that it was done, there was certainly evidence that it was in Peter's name to get a better rate. The second part of your sentence, for the benefit, if you will, of James and Jamie, that's not what Peter testified to, right?
Well, I don't think that's what Peter didn't testify to that for sure, because he's saying it's not even a gift. But other people testified to the fact that that this was in order to get a better loan interest for James and Jamie, and for them to have what they called their forever home. So, and in terms of this constructive trust, it's not just whether or not there's a true fiduciary relationship, but it could be in a more expansive reading that this court has found, where there's a confidential type of relationship or some sort of reliance on another person's greater financial or superior knowledge, trust in their business sense, and that's precisely what the evidence shows in this case. That they were relying on Peter for his advice, for his, superior credit rating, for his superior knowledge. They looked at the houses together. They were involved in relying on it. And when he came up with the idea, hey, we can get a better interest rate if you put this in my name, they agreed. And then everyone operated in accordance with that agreement, and there doesn't need to be a written document that says that.
What if I disagree with Judge Michaud's conclusions about fiduciary relationship? I mean, our cases are very, I think, tend to trend against finding such a relationship between family members. Is that a critical component to a constructive trust?
I don't think so. I think the case law is that familial ties alone aren't sufficient to support a constructive trust or, the finding of a fiduciary relationship. But there can be more. So certainly because you're a family relationship doesn't preclude the finding of a confidential or a fiduciary relationship.
But so is here the more the potential for unjust enrichment?
Excuse me?
Is the more the potential for unjust enrichment if a constructive trust is not imposed?
I don't think that it's totally alone the unjust enrichment in this case or in the case law, but it could be a familial relationship plus the reliance and the superior position of someone and the other party placing their trust and reliance on that person.
So in what way did your client rely on this?
Well, like during the process, as in the testimony, you'll see that they are looking for the houses together. There's this sharing of the financial information, both of Jamie Patz and James LANNON to Peter LANNON. There's this discussion of what is the appropriate rate. Let me take the loan, let me get the loan, I have better credit rating, your credit rating isn't so good, we'll get you a lower rate, and then we'll put the title in my name solely, and you can benefit from that. And then there's also discussions about whether or not there's, is it appropriate to get flood insurance, and what's the flood risk? So they're turning to Peter LANNON throughout the process for advice. Excuse me.
Asking your dad for advice on how to buy a house and what insurance to get, that seems really thin for a fiduciary duty. Wouldn't that make virtually every parent a fiduciary for their children's first house purchase?
I understand your concern, but in this case, it's a factual finding about whether or not there's a fiduciary and confidential relationship, and I think the judge has discretion to make that, certainly the discretion to find the constructive trust and make the factual finding whether or not there was a confidential or fiduciary relationship, and I think that also would have to be reviewed under a clearly erroneous standard. And in this case, on this set of facts, given the the situation here, they were reliant on that, and they did depend on him. And it was also, I think importantly, Peter Lannon's idea to put the title in his own name. And then everybody operated under that understanding, in accordance with that. They paid all of the mortgage, all of the interest, all of the rent, all of the insurance, taxes. They made repairs, maintenance. James Lamb was also a skilled tradesman, so he was involved not only in, making those decisions, but also physically doing that. And, we all have properties, and we know if we don't own them, we're not going to be going and building decks and redoing bathrooms. But that's what happened here. And that goes to the unjust enrichment, but I also think it informs the relationship of the parties and how they were all operating under this. And again, the writing isn't crucial to that, and certainly the statute of frauds isn't applicable when there is a finding of this breach of a confidential relationship, not to mention the partial performance issue.
In your conclusion, in addition to asking for us to affirm, you also ask us to direct Peter to transfer record title and to direct James and Jamie to pay him. I didn't see anywhere where you asked for that below. Am I missing it?
No, I don't think that was asked below, and I think that is an issue that would have to be decided in terms of whether or not you remand for the judge to decide that, or if the court had discretion or the power to do that. I think that is left the parties in this situation where, what's the next step? So I think it's important to at least address how we should go forward. If that needs to be, brought back to the trial court so he could make that finding or order, or whether or not the appeals court could do that. I think it was important to raise, because I do think the parties need guidance on what's the next step.
I don't see any other questions, but you still have time if there's anything else you'd like to tell us.
Okay.
You don't have to take all the time.
All right. Well, I think we've covered the points, so I'm going to rest the rest of my brief, and I appreciate your time. Thank you.
Thank you all. The case is under advisement. Thank you. Our next case is Sylvester BRITTO versus Back River Bog Company, LLC, and another, docket number 24P1271. And just for the parties in the courtroom, after this case, we will take about a 10-minute morning recess. Mr. Courtney, we have you twice today.
Yes, and once in the
You do that on purpose.
once in the other courtroom. So
Oh,
this,
it's a
this is
threefer.
my
Okay, it's a
this is
hat
my
trick of the
second
day.
today.
When you're ready.
Okay. May it please the court, Dana Curhan for Back River Bog. No one in this case disputed that the defendant's employees cut down approximately 30 trees on an embankment next to the bog. But the parties disputed whether the trees were on property owned by Back River or by Mr. BRITTO. And as the plaintiff, BRITTO had the burden of establishing that the trees were in fact on his property.
So usually I like to give at least a little time for you to get yourself rolling, but it kind of jumped right to the question. Where do I find a case? Because I looked that says that he needed an expert as opposed to him saying, well, I've been walking this land for 70 years and I know the boundaries and here's a map that shows it. And if I can't make hide nor hair of it, but if a jury can, why isn't that enough?
Well, I mean, there are things that are probably clear. So, you know, the land was bought from, I believe, a Mr. Baptiste. The plans that you see in the record appendix were produced essentially to locate his house. Now, if everybody said, or if he said, there's a dispute as to where the house is, it's pretty clear that that's where the house is.
So let me just so I understand though, but you're not suggesting then, as a general proposition, that where there is a boundary line dispute, an expert, a surveyor, you name it, is required?
I think in the present context, it is. I don't think...
That would answer my first question as no, but.
I think there may be cases where it's pretty clear.
Okay.
Let me ask you something even more fundamental. We held a few years ago that if you don't move for a directed verdict at the end of all evidence, you can't raise your directed verdict at the close of the plaintiff's case. And you didn't move for a directed verdict at the end of all evidence. So why can we review this at all?
Well, I think this is, there are a lot of things that are unique about this case. I think that's one of them. The problem is that at the end of the plaintiff's evidence, there was a motion for directed verdict. We then presented a witness who said, look, 5 of the trees are actually on BRITTO's land. Not all of them, but 5 of them are. So I think that that motion really, to renew it and to move for a JNOV, I think that really handcuffs us in raising that motion. I don't think the motion is necessarily appropriate. I think this is a case where...
Yeah, but what can we do about that? It's SJC precedent that unless you renew at the end of all evidence, you can't raise it on appeal. So what can we do?
Well, I mean, I think this is probably distinguishable from what the SJC says. It's analogous to a criminal case where you can move for a directed verdict for a required finding and then...
Right, except the rule is different in civil cases based on the way that the federal rule has been interpreted from the beginning. Well, why would we, how could we go to the criminal law in a civil case?
Well, I think in the present context where that motion, at least a significant portion of that motion is no longer applicable because we presented evidence and that evidence established something different from the directed verdict motion at the end of the plaintiff's case. I didn't see any cases on, what happens in that circumstance. So that's where I think it's distinguishable from the SJC cases. And, again, I appear all the time where I make that argument. But I don't think that argument really applies here. Because, again, we did, our expert conceded part of their claim. So, and then when you look at the evidence that came in, even BRITTO said, the deeds, I have a bunch of deeds that I introduced, and he conceded that these deeds aren't clear. And the maps, you look at the maps, they're not clear. They don't really establish where the boundary is. I mean, he says that I've always known that the boundary is the middle of the road.
But that's a question for the fact finder, right?
I mean, I think that is a question for the fact finder, but I think he also has to present enough evidence that...
To get over the rail.
To get over the rail, and I don't think he did. It may be close, but I don't think he did. And especially when you have our own expert who came in and said, look, we actually own up into the... up into that embankment. It's not the middle of the road. And there is a real dispute there, but I think the point is that the plaintiff never, aside from his opinion, he never really established that point. Now, again, if he was going to say Mr. Baptiste's house is like right in the middle of that lot, we wouldn't have a problem with that. I mean, everybody knows that, and it's not really being disputed. But the question is, where's the boundary? And I think you have to present some kind of professional to say, the boundary actually is here, because these plans were not made to establish the boundary. They were made to establish, where the house is, and nobody really cared where the boundary was. So I think that's my point with regard to that. Now, there's another issue, and that's what the jury instructions were and the verdict slip was.
Did you kind of give up on that one? I mean, it was sort of, well, wouldn't it be better to do this? And the judge says, no, actually, I think it's more confusing. And then it figuratively was like, nah, okay.
Well, as appellate counsel, I always wish that everything was better preserved and everybody stood in their head.
How is it preserved in any way? There's my question.
How is it preserved? Because counsel pointed this out and said, there's a problem with this verdict slip. And the problem with this verdict slip is it seems to present all or nothing. And we have, our expert said, it was sort of 5 out of 30 trees were on their property, the rest were on our property. And neither the verdict slip nor any of the instructions actually gives the jury, notwithstanding the argument of counsel, but it doesn't give them a basis to say, some of the trees were here, some of the trees were there.
Except that after that conversation with the judge says at transcript 416, are you satisfied with the verdict slip?
Well, I think it's, are you satisfied with the verdict slips? Subject to our earlier discussion, the judge made it very clear that he was.
Well, it doesn't say that, right? And the defendants don't, over the next 4 pages, there's no objection. They didn't request additional instructions. So, to Justice Brennan's question, is it preserved?
I say that it is preserved when counsel brought it up and and raised that issue, and the judge said no.
So when your predecessor, let's call it an objection, objects, he refers to his verdict slip. I didn't see that in the appendix. Did I miss it? The proposed verdict slip from your predecessor?
I'm not sure if he had a proposed verdict slip. I think there was some proposed instructions.
He said, I think we proposed on ours just asking the jurors to identify the number of trees that were cut just to clarify that.
There may have been, I didn't see it when I was putting together the appendix. Maybe I missed it, and I can certainly inquire. But I'm not sure. I'm not sure if that was submitted. I'll have to look.
It'd be real helpful to see that, to understand what he's saying, if it could be tracked down. It's not available online.
If it's not available online, I'll have to see if there
or at least I couldn't find it online.
It may not have been filed, so we may not have that. But I guess the point is
we have the proposed instructions, right?
we do. So the point is that again, things might have been done better, but I think the jury came up with an all or nothing solution, and I don't think that was appropriate. Unless there are any further questions, I'll leave the remaining points of the briefs.
Justice Ditkoff? I think we're all set on that.
Thank you.
Thank you so much. Attorney Watt.
Good morning, Your Honors. May it please the Court. I'm Alexander Watt. I represent Sylvester BRITTO in this matter. I'm going to largely rely on my brief, but there's a few items that I just wanted to comment on. Whether an expert is needed, and I was able to find no per se rule about whether an expert is needed in surveying or that in terms of determining a property line. It's clear from the record that the judge did consider the plans and the evidence in her ruling on the motion for a directed verdict, that she felt it was within the common understanding of a jury to make. So I think that's within her sound discretion. And I think just as a matter of looking at the facts, I think the fact that there's a recorded plan and it says a plan of land for Peter Baptiste, I think is within the realm of people's understanding. Just one thing I wanted to clear up. There is an indication that these plans for Baptiste were made to locate his house. I could not find that support for that in the record per se. There are two plans. One, they were both in the early, I think, 1990s. maybe early 2000. One plan showed the property where BRITTO abuts the cranberry bog. And then there was a separate plan which in fact did show the lot for the house. With respect to the appellant's expert surveyor, he came up with an opinion that this property line might possibly be at the top of the embankment. I think it's important to note, though, that we have the Baptiste plans were actually recorded at the Registry of Deeds, and this was a plan that was just prepared in terms of the litigation.
That's a factual question for the jury, right?
Absolutely, and I think when I pressed the surveyor at time, he indicated that it was speculative and it was based on evidence, based on a prior plan.
Do you want to speak to the issue of the lack of a motion for a required finding? Or directed verdict?
I think I just referenced it. I didn't brief it too much. I referenced it in my brief. Then I noted that they did not renew the motion for a directed verdict or ask for a judgment notwithstanding the verdict.
What do we do with it, though, from your perspective? Because I think as Mr. Curran points out, I mean, the SJC has said what they have said on the one hand. On the other hand, it would be rather disingenuous for the council to stand up after his own experts said, well, 5 of the trees were over there, and then to renew the motion for a directed verdict.
Well, Your Honor, as I understand, I didn't rebrief that issue, but it's my understanding that that is the law, that you were supposed to renew at the end of all the evidence your motion for a directed verdict. So I think it would be waived in that circumstance. One thing I did want to say on the issue about jury instructions or the verdict slip, and I didn't raise this in my brief, but in reviewing last night, I do note that if you look at the appellant's requested jury instructions, they're clearly indicating an all-or-nothing approach. If you look at requested instruction 2 and requested instruction 3, those are at Record Appendix 53 and 54. There's no request for a parsing of whether this tree was on the property or that tree was on the property.
Do you recall if there was a written proposed verdict slip?
You know, I don't recall. I don't think it was. I think we had some discussion among counsel suggesting one slip or the other. And I think we went through some iterations of that. But I don't recall that there was ever one submitted to the court for formal request. Nonetheless, I think to the extent that the appellants have a point there, I think the judge gave them ample opportunity to address that in their closing arguments. And they did, in fact, address it in their closing arguments. I think it could have been a little clearer, maybe, but nonetheless, they were given the opportunity to do that. I think I'll rest on my brief unless there are any further questions.
I'm just going to check with the panel. I don't see any. Thank you very much. The case is under advisement. Counsel, thank you both.
Thank you, Your
We are
Honor.
going to take about a 10-minute morning recess. When we return, we will hear the Department of Children and Families case.
All rise.
Good morning again. We are back on the record, and our next case is the Department of Children and Families and Another versus Mother and Another, docket number 24P949. I want to remind council that this case is impounded, so please do not use any names. My understanding, we had entered an order regarding child's participation in this appeal, and that Ms. Healy and Ms. Moucherit are splitting their time 7.5 minutes each, and then we will hear from Mr. Cuttle for the department. So with that, Attorney Healy, are you going to argue first?
Thank you.
Wonderful. Good morning.
Good morning. May it please the court, my name is Julia Healy, and I represent the appellant mother in this matter. I would like to address the court's 6/11/24 denial of mother's motion to reopen, and my sister will then address the lack of clear and convincing evidence in this case. On April 2nd, my client was in custody for 9 days because she voluntarily removed a warrant. At that time, the court held a trial and found her unfit because she was unavailable. Prior to that finding, my client had twice asked the court to delay that finding, stating that she would be released from custody 3 days after.
Twice, there was a motion to continue filed March 21st.
Yes, sir.
And then the other one's at trial, statement at the trial?
There wasn't a motion filed at trial, Your Honor, but she did ask at trial. It's in the transcript.
That's the second, when you
Yes,
said
sir.
twice. I didn't see the motion to continue in the appendix. I assume it didn't say, I'm going to be arrested in a few days.
It's not in the record what it said, Your Honor. I can tell you it was filed, I believe, 7 days before she went into custody.
It's in the record, right? I mean, it's not in our record, but you,
It's not in the record. I was unable to put it in the record appendix.
why not?
It wasn't available to me.
Really?
But when I
That's-
asked the court, I wasn't able to obtain it.
Wow.
I don't know why.
Do you know what it said?
I don't, Your Honor. My trial counsel was also on leave, so I was.
Yeah, no, it's just weird the court can't produce it. That's, wow, okay.
So why should the judge have accepted the representation that your client was going to be released in 3 days or whatever it may be? I mean, she tendered a plea, and I saw that, and she got 12 days deemed served, but that's certainly by no means a guarantee. How do we know?
There was no guarantee, Your Honor, but she
Right.
did represent at trial that she had spoken to probation, I believe it was probation. She had spoken to probation, and that her case was going to be dismissed in 3 days, and she was going to be released from custody. Given the fact that it was three.
So actually, the case wasn't dismissed, right? She was found in violation, and then she was given the time deemed served.
Right, she was dismissed on, I believe, April 5th, and the trial was on April 2nd. So had the court held the trial on April 7th or even 6th in the afternoon, it couldn't have found her unfit because she was unavailable. The court literally held the trial in the 9 days in which she was in custody in her entire life, I believe, and put its foot down and said, I'm holding it now and I'm finding you unfit. And then in June, after it denied the hearing on the motion to reopen, put in its findings that it found her unfit because she was unavailable when it knew full well at that point that she had been released
But
from custody.
isn't the judge supposed to figure out everything as of the date of trial?
Yes, the judge is supposed to take everything in front of her and make a clear and reasonable decision and not abuse her discretion, which is what she did. She had good reason to believe that she would be released. There was no, my client at the day of trial didn't ask that the trial be continued, just asked that the court reserve a finding of unfitness for 3 days until she was released, so that she couldn't find her unfit because she was unavailable. That's a completely reasonable thing to do, and I would argue.
Well, what about the fact that, and I might have the timeline wrong, and I apologize, but this warrant had been open and pending for, I think a year, and Mother had made, as I understand it, numerous representations that she was going to clear it up. So isn't the trial judge, she's not considering this in isolation, like she's in custody today and this will be resolved in 3 days. I mean, the thing had been pending for a year.
I believe, Your Honor, that yes, it had been pending for a year. I believe she once said that she was going to remove it a year earlier and didn't, but she also told the court that she didn't remove it when she was pregnant because she didn't want to be incarcerated when she was pregnant. She then didn't want to remove it after she had her children because she was afraid that DCF would remove her children, which was a very rational fear, seeing as DCF removed her children twice during the case, once because she had sleep apnea and once because she was discharged from a program, neither of which had to do with her parenting. So she knew what DCF was capable of doing, which they in fact did. She had very good reasons for not removing the warrants earlier.
I mean, don't you think being a fugitive from the law makes you unfit as a parent?
I don't believe not removing a warrant is a fugitive from the law. They knew that she had a warrant. If law enforcement wanted her, they could have just called DCF and found out where to find her.
Wouldn't that mean the first time she's driving the car with the child, she's going to get arrested and, gets pulled over? And isn't that how it happens when there's a warrant over?
Well, actually, Your Honor, she didn't. She drove, well, I mean, she
I understand,
took a bus.
but
She didn't drive, but
if you decide to just stay a wanted person, then the first time you have a police encounter, you're going to get arrested and child's in the car, and then the police are going to have to figure out what to do. I mean, doesn't that seem unfit?
I do not believe that makes you unfit at all, Your Honor, especially if you're my client. For you and me, who haven't had the experiences with DCF that she had, yes, would we have made a different decision? Having the, privilege or whatever you want to call it of being who we are, yes, we probably would have made a different decision. But you're talking about a woman who had just tackled the substance abuse issue on her own, I will say, who had then done everything that had been asked of her and still had DCF breathing down her throat.
Let's sort of jump at the elephant here, if you don't mind.
Sure.
Which is, how in the world is the child not with the mother now? Like, what's happened since? I can't understand how we got to the 6 months determination point without the child being returned.
That's my question. Honestly, I almost thought about opening this up by saying, I don't understand why we're here. This is a woman, and my sister will speak more to this, but this is a woman who did everything she was asked, who was sober her entire case. Not one slip during the case. She did slip when she was pregnant and then got herself right back up and had 9 months sober at trial, and I believe had 11 months sober at the motion to reopen. She did every single service that was asked of her. She had check-ins with her social worker at 3 months, 6 months. I mean, all of these check-ins, her own social worker said she didn't understand why.
You don't know what's gone on since?
I'm sorry, sir?
You don't know what's gone on since June? Like, I got the docket, and it didn't reveal to me.
No, I honestly don't know what's gone on since June. I'm sorry, Your Honor.
During the motion to reopen, if I recall correctly, DCF represented that your client had been rearrested for some other crime of violence, no?
I don't believe she was rearrested. I believe she
Or she was charged, had new charges, she has some new charges since she got released from jail.
Recently, you mean, Your Honor?
No, that was, as I recall, during the motion on June, during her request to reopen the evidence. They said she was arrested on new charges. I'm looking at the transcript, 208 to 210. Let me just find it.
Perhaps my brother can speak to that.
Yeah.
I don't know. That's not ringing in my memory.
It's my understanding that following Mom being released that Friday after trial, she was subsequently rearrested on a new offense that they have as an assault and battery offense, and then was released again. So you don't have any information on where that case or what's going on with that case?
I don't. I honestly, and I apologize, don't even have a memory of that. Who is speaking in the transcript, Your Honor, if I may ask?
That would be Mizinos.
The DCF caseworker?
Yeah.
I don't know, and I don't believe there was anything on a Board of Probation record or anything else to support that statement.
We don't have an updated,
I do.
Carrie, we don't have an updated Board of Probation record in the
And I don't
record.
have anything updated either, Your Honor. I see I'm out of time. If there are no further questions, I'll rest on my brief.
Thank you. Attorney Moucherit?
Morning, members of the panel. Morning. Chief Justice Michelle Moucherit on behalf of the appellant child. I'm here to ask this court to vacate the lower court's decision granting permanent custody to DCF and remand this case for further proceeding for the following reason. A judge must make specific and detailed finding in care and protection cases to demonstrate that a close attention has been given to the evidence, and the finding must prove current and fitness clearly and convincingly. Mother testified that during her pregnancy, and as soon as she found out she was pregnant, she entered detox. She reached out to Moms Do Care, and she ended up in a program, the Heart House. However, looking at the findings, although the judge issued 39 findings, there's not a single finding that refers to the mother's steps that she took and her being proactive during the pregnancy.
Yeah, but she's incarcerated. I mean, isn't she unfit on the day of trial? She's
The day of trial,
in
she was
jail.
incarcerated. That makes her unavailable. And this mother made a plan, concrete plan. She told her social worker that she would like to propose a placement resource. Her friend, Miss W. That's a plan.
Right, but didn't the judge,
Sorry.
go ahead, Justice.
How can the judge return the child on that day when she's in jail and she's got an idea of who'll take care of the child, but we don't even know whether that person's willing to?
Well, this is when it gets tricky. It gets tricky because DCF has the information about this woman. Yet, according to the social worker, there was no study done on her. And this mother gave DCF this information in March when the child was removed. It is DCF's role and job to do investigation and make sure this mother, Miss W, is ready, willing, and able, and the standard, housing standard, meets DCF's requirements. They never did that. In fact, the judge requests that the mother should have brought that woman to testify is more of shifting of the burden.
Can I ask, I know that this is somewhat outside the record, but I'm baffled by this case because there's been no termination, and we got an updated docket, and it doesn't appear that there's been an R&R. So I know I'm asking you to go outside the record, but what's going on?
So I can tell you I met with my client as recently as last Wednesday. He's still in the same home.
With the other two siblings?
With the other siblings.
Okay.
I am unclear to why R&R has not been filed, maybe because parties are waiting for this appeal. I don't know. However, according to the docket sheet, no R&R has been filed.
Because the judge, right, she says, let me just find it. I believe she says that the goal still was reunification. So I don't want to say what are we doing here, but in a way, what are we doing here?
Exactly. I agree with the court, Your Honor, and I agree with my sister counsel. What are we doing here? So it's unclear.
Mom's appeal. That's why we're here.
So that said, the other issue I'd like to bring to the court's
I apologize. I believe I interrupted Justice Brennan. He might just.
Okay, I'm fine, thank you.
Thank you. The other issue that I'd like to raise is the insufficiency of evidence here. The court relied on stale evidence. For example, the court relied on mother's history of substance use. The court relied on the mother's history of domestic violence. The court relied on mother's history with the DCF. The court relied on mother's criminal record.
Well, at least as far as the criminal record, it was still active, right? She had pending cases at the time, a pending probation violation, a pending criminal case, so that at least was current as it could be, as Justice Ditkoff pointed out, since she was held in custody on it.
And I agree with you, Justice Brennan. Okay. However, adoption of Frank tells us that the evidence of prior conviction can only be relevant to the extent that they bear on the parental fitness. I called the court's attention to mother's carry, which was an exhibit, and there was no convictions. There was a lot of dismissal.
Why isn't an admission to sufficient facts the equivalent of a conviction? I mean, she admitted to sufficient facts on malicious destruction, domestic assault and battery, and normal assault and battery. Why doesn't that count as criminal activity where she admitted she did those things?
I believe she quaffed. With the quaff, it comes a certain time of probation, and she completed the probation, I believe, in prior conviction and not conviction charges. And that's how the case got dismissed. She was in compliance. So
I think she was actually on that probation at the time, which is why, and she had defaulted on her probation. That was the reason for the notice of violation in this case.
Okay. The court also...
And to Justice Ditkoff's point, the only way you get to a continuation without a finding right is through an admission to sufficient facts, which is the functional equivalent of a guilty plea, just a less formal way. I mean,
but I also...
for the purpose of what we're doing here, I would think.
Sorry, Justice.
Okay.
Brennan. I also remind the court that she made a plan for this child. Whether she was going to be detained for extensive period of time or shortly as she expected, she made a plan for this child. We also have the issue of the court's...
Can I ask you, I'm sorry to interrupt you, on that question, understanding that you're saying we don't shift the burden to the mom, and DCF could have and perhaps should have done an investigation, but they didn't necessarily know that she was going to be incarcerated on the day of trial. So when she comes up with the backup plan of having her friend, isn't it then incumbent upon her to bring the person forward so, as the judge said, I can at least see, is this person willing and able to take the child?
I agree with you, Justice Brennan. The issue is that she provided DCF with this contact information of this woman in March when the child was removed.
But she was still out in March. That's my point. She was still out and about in March, and so she was as viable as perhaps the other person. The other person, it seems to me, only became critical when she was not, at least in the moment, available.
She was still out in March. However, they removed the child, and she wanted them to place the child with Miss W at that point. So Miss W has been the plan for the mother since then.
So let's say DCF does an investigation in March and the Miss W says, I'm great. Still, when we get up in the day of trial and the judge is looking on the Zoom and sees the mother on Zoom because she's in Framingham, and then says, okay, what am I going to do? Who's the child going home with if I give you what you want? And she says, oh, this lovely woman. And then the judge says, well, where is she? Don't we have a problem there?
Well, to certain
It's not DCF's fault, at least in that moment.
Well, yes, the mother could have, would have, should have, but we're here because DCF did not do its job. The social worker testified she had the information all along and nothing has been done to investigate Ms. W. I also would like to raise another issue.
We're going to have to leave it there on your briefs. Thank you, counsel.
Thank you.
Mr. Cotto, this is Chief Justice Blake. I will make sure that the judges say who's speaking before they ask questions, and I will notify you of the time, okay?
Thank you. Thank you, Your Honor. William Cotto for the Department of Children and Families. I do rely on the department's brief. I know there's an unfitness issue and the abuse of discretion issue on the motion. Does anyone have a preference of what would you like me to address first?
This is Chief Justice Blake. Can you address the denial of the motion to reopen the evidence first?
Yes.
Thank you.
It was a little bit confusing with the procedural history, at least it was for me, trying to follow along the different steps that the trial judge took in this case. The trial was on April 2nd. There was going to be there was a second trial for an unnamed father that the trial judge waited on holding until notice was properly sent out. And mother did file the motion to reopen the evidence on May 28th. The actual hearing took place on the 6th of June. There was no witness testified. The issue wasn't as cut and dry as counsel has set forth here. At the end of trial, the judge was, as you have recognized, in a no-win spot because mother wasn't available. Mother's witness that she was relying on wasn't there to testify. And the court did say at the end of the trial, this is a difficult, I'm paraphrasing, this is a difficult situation. As you all know, I'm concerned that mother's not available. But the court also said that the department had met its burden of proof. And what happened at the hearing was the court heard proffers by the different parties. Nothing really had changed. The court was aware that mother had been let out of incarceration. There's no indication of exactly what happened on the record about that, but the court was aware she was out. But what's important here is that in making the decision, in denying the motion, the court incorporated its findings of fact, which she had completed on June 5th. So the trial happened on April 2nd. Little less than 2 months, she had also had the opportunity to go through all the evidence at trial, and she found that mother was unfit, and she attached those findings in support or in reference to her denial. And what's interesting about that, and what counsel hasn't brought forward here, is that the issue was not just that mother was not available on that particular day. This is a case about a young woman who's had a difficult life, obviously. She lost her 2 earlier children. She, on her own, testified that or told the court investigator that she called herself a reformed drug addict, who made a lot of strides during the case in terms of her substance abuse treatment.
Counsel, this is Judge Ditkoff.
Yes.
It seems like you're saying that the reason the denial of the motion to reopen was okay was because there was enough to find the mother unfit, even putting aside the incarceration.
That's correct, Your Honor. That's absolutely correct. Because in this case, mother, she wasn't able to stay in 2 programs. She was able to work on her issues, and she was just beginning her sobriety. You know, it's clear there's no issues being contested. Mother relapsed during her pregnancy with her child. But to her credit, she took advantage of the services that were offered to her during the case. The judge acknowledged that, but she couldn't stay in these 2 programs. She was unstable. Our department report indicated that mother had to leave the St. Mary's program, the first program, because of conflicts with the staff. Mother testified at trial herself, saying that she was terminated from the Porter's House, the second program, because of a verbal altercation with another resident there. That issue, the instability of mother and for the child, was a major concern to the court. And just to reemphasize, as everyone is clearly aware, mother had and has the right to go back to the trial court for a review and redetermination. I believe that the actual 6 months was rough justice here, but it was somewhere around December or January. She could have gone back. She hasn't gone back. There's information outside the record about that, but that's not my place to inform this court. The child was found unfit by the trial judge based on the evidence, and the court properly denied the motion to reopen the evidence. The only other thing I'd like to say to the panel, and I don't want to belabor this point, I understand that General Laws 119.27 is unforgiving in terms of its time period to file a notice of appeal. The department, I do object to the child being able to argue as an appellant, but I'm not going to belabor the point because I certainly understand why this court wants to hear from children.
Judge Ditkoff, isn't the child at least an appellee? I mean, it seems to me the other option is the child gets half your time.
I usually split my time, Your Honor. It's not a real concern to me. I've never been on this side by myself before in 22 years, so I don't want to make an issue about it, but I just have to put that on the record.
Judge Ditkoff, still, I understand you can't go to stuff that hasn't been in court at all, but can you tell us what happened at the July 2024 hearing in front of Judge White?
July 20, no, I do not.
There was a hearing from Judge White. Permanency plan is to return child home, determination of reasonable efforts made, and then the next thing I see is a notice of intent filed by your predecessor in October. I don't know, intent for what?
That was it, Judge White, because this is a Boston case.
This is Judge Blake. It's the new judge, Judge Fabiola White.
Oh, okay. I don't know about that, Your Honor. I could just. In most cases, parents who have an opportunity to go back would go back. And the department, quite frankly, if the case isn't moving, the case should go back by the department, because this child needs some permanency.
Well, this is Judge Blake again. Do you know what the docket entry notice of intent filed by the department, what would that typically mean?
That would mean the department's moving to terminate parental rights.
Oh. Okay.
Which would mean, in theory, that circumstances have changed. That's what it would mean in general terms.
And obviously, for all counsel, we're just deciding this case on the docket that's before us. Mr. Cardinal, you have 7.5 minutes remaining on your time.
I don't need the time, Your Honor. With all due respect, I'll rely on the department's brief. Thank you very much.
Thank you. The case is under advisement. These are always very difficult cases, and we appreciate counsel's efforts on behalf of everyone. Thank you so much. Our next case is PH versus GS, docket number 24P1078. As counsel approach, I remind you that the case is partially impounded, which means please do not use any names of the parties. Is this number 2 or 3, Mr. Curhan?
This is number 3.
All right, so you're done after this one?
I'm done after this one.
All right, Attorney O'Neill's been resting up, so I just want to prepare you.
Okay.
When you're ready.
May it please the Court, Dana Curhan for the defendant. We challenge the sufficiency of the evidence to support the harassment prevention order. This was a...
So can I ask you, I know you
course.
never like to concede anything, but we have 3, I'm going to focus on the 3 acts more so than the ex parte order for a moment. We have June 2022 at the post office, the spring of 2024 at CVS, and then the scooter in front of the house in April of 2024. So I'll just ask you, would you concede that the last act, the April 2024 act, could qualify under the statute?
I don't concede that, no.
Do you think any of the acts qualify?
I don't think any of them qualify.
Can I ask you a related question on the scooter incident? There's a video of that the judge saw that I don't think we've been given. So how can we review that one without seeing the video?
I don't know. They gave me a thumb drive, and it didn't work. And I went back, and they said, "Your problem, not mine."
Who's they?
The clerk's office at the district court. So I have not been able to get a copy of that video. I mean, but I think from the testimony, all 3 incidents follow the same pattern, where my client made the same rant, which is...
Is it fair to say the reason that, I mean, I'm going to parse all 3 and continue to parse all 3 with you, because that's what I do, right? But your view is it doesn't matter because it's all a First Amendment issue.
It's all a First Amendment issue, and in order to prevail on this threats theory, there have to be 3 incidents that constitute fighting words of true threats. So one incident that might be a threat is not enough. So you look at Senni versus Morhe, there was a threat to punch the plaintiff in the face, plus an incident...
What if it was accompanied by physical conduct? For example, when... Well, the judge credited it, so assume for the moment when PH tried to leave and GS stepped in front and at the post office and essentially prevented him from leaving. Why is that physical act in conjunction with the words not sufficient to rise to the level of intimidation at least?
because there was no true threat, there were no fighting words. He stood in front of him and he said what he said.
Say he said nothing at all. Let's assume he said nothing at all, and the man just wanted to leave the post office, and your client shadowed him or stepped in front, and then he took a fake right, go left, and there he is again. In context, isn't that behavior, at least, without the words, sufficient for a judge to find that it fits the criteria of 250-AD?
I'm not sure, and I don't concede that. What happened, and that's not what happened here. He said his piece, and then he left. He moved out of the way. And what he said was, essentially, you ruined my son's life, you suck up to big donors, and you are a piece of S. So then that's pretty much apparently what he said, all three incidents.
Is there anything that we can glean, as the judge apparently did, from the testimony that however your client said what he said at the CVS, it was sufficiently alarming that someone else there intervened and indicated they might call the police? Doesn't that give some sense as to the, again, beyond just words, the tone and the dynamic that would occur that might at least allow a judge to infer that there was something intimidating or threatening about the conduct?
Again, I don't think so. I mean, if you go into a store and you're being loud and you're saying something that is protected speech, somebody at the store might say, take it outside or I'm going to call the police. The transcript at the contested hearing, page 45, on any of these occasions, he never used any words threatening you with physical harm. He didn't say, I'm going to punch you in the face, I should punch you in the face. He didn't use any threats like that. Answer, no. In fact, he didn't say anything like, I should scratch your tires, I should hurt your dog, I should paint your house. He didn't threaten any harm to your property either, did he?
My page
No, he
45
didn't.
is the ex parte hearing.
It means page 45 of the second transcript.
Oh, they're not numbered, unfortunately.
Yeah, they're not like we normally, I like it better this way, frankly.
Can you tell us what the appendix page number is? I just want to be able to follow along.
I think
It's, right.
Oh, 98.
98? Okay, thank you.
Yeah, I think I'm looking at the wrong, I think I'm just looking at the transcript, not at the appendix volume. So I apologize, but it is on
Okay.
Yeah, it's 98.
45 of the second hearing. So, that's really the problem. I mean, there are three ways of showing a violation or three ways of supporting a harassment prevention order, and the complainant and the court relied on the threats prong of that. And, I think just the contents of the speech, it wasn't very nice, and I'm sure the complainant found it to be very upsetting, but it was really no different from a lot of the...
Can I just hold you for a moment? Because
of course.
as I read the judge's finding, she not only found engaged in a series of, engaged in behavior in a series of 3 acts of willful and malicious conduct aimed at the plaintiff with the intent to cause fear, intimidation, or abuse. So I'm not sure that it's isolated just to verbal threats.
In fact, she said it's not
Thank you.
the speech that concerns me.
Right, thank you.
Well, but, what is the behavior? I mean,
So, sort of imprisoning someone in a post office, acting so out of control to CVS that the pharmacy calls the police, and scootering over to someone's house.
As to the...
Present.
His wife's present.
So just say, for example, the post office incident, just say that is countable, which I don't concede. But what is the behavior at the CVS? He raised his voice. He didn't block him. He didn't physically restrain him. He did
It
not
was
threaten
alarming
him.
enough that a third person unrelated to them felt that they had to call the police. Can we infer anything from that?
No.
What about that he approached him? Didn't just stand and randomly began using profanities, but says, the judge's finding says, saw the defendant, although I think she miswrote, when the defendant saw the defendant, I think she meant when the plaintiff saw the defendant approach him and began the same rant using profanities, calling him names, et cetera, which made the plaintiff nervous and caused the pharmacist to be concerned and offer to call the police. So it's behavior of approaching. What if you approach someone in a particular manner? And that seems to me to be a question of fact that a judge can find or not find.
Well, I mean, you look at Senny versus Morhe. There was an incident where the defendant verbally abused the complainant. That wasn't enough.
Right.
He sent him a nasty email.
So again,
That wasn't
an email presumably was not in a place where you're being confronted. I'm focusing solely on behavior. I agree. If he shouted across a parking lot, okay, fine. But in this case, the judge found that your client approached the plaintiff in a manner that caused the plaintiff to be afraid.
Well, I mean, you look at the scooter incident. He approached him from a distance from the street, didn't get off his scooter, and yelled the same rant.
I think
And then
for
turned around
that
and
one,
left.
it was the come on back U-turn problem. If you're going to, yeah, if you just scooted by the house, maybe you're having a different conversation. But if you scooted by the house, stop, and then intentionally turn back, again, I'm trying to understand why a judge cannot, I may not, but why a judge could not have found that reasonably, to be behavior that reasonably placed this person in fear.
Well, I mean, what if the person in the house was the mayor of Somerville or something, and he came back and said, I don't like the way you're doing your job, in a very loud tone of voice. That's protected. It's not threatening. The conduct itself is not threatening.
What if the mayor tried to get by and the person stepped in front and wouldn't let the mayor pass?
I mean, closer question. But, what we have here is arguably that happened at the post
I think we're in a
office.
different conversation, too, if we're talking about a public official.
Right, and then he said what he said, and then
not to mention my grandfather was a former mayor of Somerville, so let's stay away from that.
Okay. I used to live.
Long time ago, though, you didn't know that.
I used to live in Somerville. Maybe I did, but I think when you you look at the totality of the circumstances, he spoke his piece at the post office, and then he stepped out of the way. The complainant did not have to, call the police and get him out of my way or get out of my face or anything like that. He said
I don't need to dominate the questions, but here's I guess my overarching, because I may not disagree with you, but my overarching question, I suppose, is if the purpose of 250-80 is to protect people from harassment or intimidation, and that's why we need at least 3. And a judge looks at this and says, okay, we have, a few years later, and the person's still heated, and doesn't let him get by in the post office one time, approaches him, in quotations, in the CVS a second time, and then scooters by the house, finds out, maybe it's coincidence, or maybe found out where he lived. Am I supposed to wait for the 4th, 5th, 6th, 7th case that might turn violent, and then from which this person may need some protection? Isn't that the whole purpose of the law?
Well, I think what the SJC has also said is that this statute is not intended to prevent you, and also 209A, to prevent you from suffering from some kind of unpleasant contact. Right. This is not something where my client went out of his way to target this complainant. He ran into him 3 times randomly. There's no evidence of anything other than that. And, he went through the same rant. He went through, a rant that we contend is protected speech. He can say that, you're corrupt, you suck up to the big donors and not my son, and you ruined my son's life. He has a right to say that to him. And that's exactly what he did. He didn't say, I'm going to hit you. He didn't say, I'm going to do anything, any physical harm to you, nothing like that. And, you know, it's unpleasant, and obviously my client understands from me and from his trial counsel that he should have no further contact with him, even if he prevails on this, this appeal. But it does not rise to the level of 3 acts of true threats, 3 acts of fighting words, or anything beyond what he was probably legally entitled to do. Unless there are any further questions, I will leave the remaining points of the brief.
Thank you very much, Mr.
Thank you.
Torhan. Attorney O'Neill.
Thank you. May it please the Court, Allison O'Neill on behalf of JH, and with me is my colleague, Max Gessman. I actually want to start with Justice Brennan's point a few moments ago, that you don't need an actual act of violence in order to get a harassment order. Though it's true that words alone may not be enough to justify an order, that's not what we have here. When you look at the totality of the circumstances that occurred, there was more than ample evidence before the trial court to allow a harassment order to issue. This court has already hit on some of the points that I wanted to make here. Looking at the first incident in the post office, my old prosecutor words would be, there was a false imprisonment. PH went to leave. He indicated that there was a rant. It went on for a couple of minutes. He said he was concerned that there would be a physical confrontation, that it could have turned physical, and that JS put himself between PH and the door. And
The one that actually troubles me the most in terms of the qualifying act is the 2024 at CVS. So make that case for me, if you would.
Certainly. PH was in one of the aisles, and JS ran up to him. That is the testimony, that he came toward me and went into the same verbal rant again. And he indicated at that point in time that he was concerned for his physical safety, that he was nervous. And it is, as this court has already pointed out, when the pharmacist asked, should I call the police? The aisles are small there. It was an approach. The last altercation was in the post office where he didn't feel free to leave. And when looking at the incident at CVS, you can look at the totality of circumstances. You can go back to that prior incident in the post office when there was the false imprisonment as well. PH indicated under testimony, and this is at the record at 65, that he was nervous and he clearly was in fear. And others, being the pharmacist, observed this behavior and became concerned enough to suggest that the police should be called.
What factual case do we have that's closest to this one?
I think that the closest factual case to this is the VJ versus NJ, the bus driving case, as well as the case that was actually cited by the judge in her order, which involved the individuals, that's the JC versus BG case, which is tenants in the same property that have share some parking, and there was some hostility amongst them. And in fact, in one of those instances that formed the basis, there was a question about whether the individual applying for the harassment order had even seen the conduct. And I think, too, there's clear evidence in PH's affidavit where he indicated that he was and remains in fear. He's clear in fear that something is going to happen to him. He makes it very clear that he is concerned that JS knows where he lives. He stated that he was also concerned for his family. As the court's aware, his wife was there. She was one of the individuals that had taken those photos that were part of the record. It's just, there is ample evidence in the record that would warrant the issuance of the the harassment order.
So your position is that it's more than the words? What about the words themselves? If it were just the words alone, would those have sufficed?
I would concede to the court that the words, that there needs to be more than the words. I would not begin to suggest that although I would say that in this case, it's clear that this was a revenge situation, which the statute talks about, motivated by revenge. And here we are years after, and it's in the record that his son was no longer at school, and in the court's decision, that JS feels that PH is responsible for that. And here we are years later. He could express his opinion that he felt that PH was motivated by donors or whatever may be, but it's the totality of the circumstances. It's the fact that it is years later as well, I would suggest, that there's still revenge that is motivating JS, that there's physical aspects of each and every one of these encounters.
Can you just as succinctly as you can identify the physical conduct that you would point to on each incident?
Yes, in the post office, barricading the door, blocking his egress from the post office. In the CVS, approaching him, coming at him in a small aisle. And at home, at the one that occurred.
There's a description of the aisle and the size of the aisle? I think I just read it.
Yes, and in fact, there's a photograph in there, and there's an indication that it's a small CVS. And the final one was the turnaround and approaching on the scooter. There was testimony not only that he turned around, but that he advanced towards PH and his wife while they were in their home, or outside their home, but in the vicinity of their home. Those are some of the circumstances that changes this to a true threat, and not just a First Amendment expressing one's opinion.
It's not terribly relevant if we accept Attorney Curran's position, but assume for the moment that we accept yours, then can you talk a little bit about the mootness of the ex parte hearing, which ordinarily, sure, it's moot, but there may have been some conversation there that just ought not to have happened, or maybe a recusal that didn't happen, or thoughts on that?
Absolutely. First off, I would say that Attorney Curran took a completely opposite position in the Noel versus Frazier case, which rendered the ex parte.
He's got to represent his client.
Absolutely, Your Honor.
Have to be consistent.
Absolutely, but that case alone would render this issue moot. But I'm happy to talk about the actual hearing itself, because it was a Zoom hearing. And I think we can all agree that at times Zoom hearings are awkward. When PH gets on, the clerk is speaking, and there's some awkwardness about whether the clerk is the judge. And the clerk, my client says out loud, is that the judge when the clerk is speaking? The clerk then says, no, it's Judge Mary Beth Heffernan would be presiding over it. And my client says sort of, oh, I know Mary Beth. But that's the extent of the interaction at the beginning of the hearing. Judge Heffernan makes it very clear that she knows PH, but doesn't feel that it'll affect her ability to
that's on the record.
That's on the record. Before the hearing.
She can be impartial.
Yes, Your Honor. Yes, Justice Brennan. She makes it very clear at the start of the hearing, before there's any testimony whatsoever. At the end of the hearing, as they're wrapping up, my client says, let's catch up sometime in a non-court context. That's it. And Justice Heffernan says that'd be nice, or I'd love to, or words of that effect. There's one other statement that's made, and my client says, how's the family? And the reason why that statement is made is that the reason why Judge Heffernan knows PH is that her kids also attended the school. It's also clear on the record that they haven't seen each other. There's no indication that they've seen each other.
Did you say that Judge's kids also went to Beaver?
They did.
That's another reason why she shouldn't have heard this case.
Does that seem like a definite recusal?
I don't believe so, Your Honor. My kids actually attend a similar school. I could walk by the head of school and recognize them, but they don't know my name. They don't know, I mean,
But she knows his family.
She knows that, he says, how's the family? That's the statement. There's a recognition there, that's it.
Can I ask you about the appendix at page 41 is the diagram of CVS. I've been in a lot of CVSs. This does not help me to understand how small or not these aisles are. So is this the photograph that you're referring to?
That is the photograph. There is, and that is the photograph, or the diagram, I should have said. It is,
It's hard to know.
it's hard to, I am familiar with the CVS personally. It is a relatively small, it's not one of the big ones. It is a small city CVS. And in the diagram, too, there's an indication of the approach that I referenced earlier.
I recognize that this question is outside the record, so just if you could give me a yes or no. Has there been any contact since the issuance of this order?
No, there's been no contact.
Great, thank you.
Thank you. If there are no other questions.
Let me see if I don't see any others from the panel. Thank you
We'll
very
rest on
much.
our
The
brief.
case is
Thank
under
you.
advisement. Thank you both.
Thank you.
Our final case on this morning's list is the Port Restaurant and Bar, Inc. versus the Alcohol Beverage Control Commission and others, docket number 24P996. I believe we're going to start with Attorney Kelly.
Good morning. Oh, is it afternoon?
Still morning. We have 5 minutes to go.
Arrange my impedimenta.
Take your time.
Members of the panel, may it please the court, my name is William Kelly. I represent the appellant in this matter, the Port Restaurant and Bar, Inc., located in Harwich. Present in the courtroom today, in candor with the court, is one of the two principals of the port, the owner, Justin Brackett, who owns the port with his brother, Griffin, as well as a sister restaurant also located in Harwich, Ember Pizzeria. I will refer to my client as the port or the appellant, and my comments made during oral argument are not intended to waive any of the arguments or positions that are more fully developed and argued in the brief in the reply.
Actually, I'm glad you brought up the word waiver, because one thing before you start, I want to understand is the appellee makes the argument at page 26 of its brief that you have waived the sufficiency of the evidence argument, and in your reply brief, you did not address the defendant's contention. So can you tell me whether or not you think you have, that issue is waived?
I would submit that you anticipated one of my comments.
Okay, good.
Chief, we did not challenge from the get-go with the first 30A complaint in the Superior Court substantial evidence for the ABCC decision. I do not deny that a transcript of the hearing days in front of the ABCC was not prepared and not filed. So it was a surprise to me, for lack of a better word, to see such an expansive argument of lack of substantial evidence on an issue that was never presented from the get-go. What we do argue...
So you concede that the commission's decision, I just want to make sure I'm crystal clear, is supported by substantial evidence?
In response, I would express it differently. We do not challenge that the...
What's the difference between you do not challenge and you will not concede? I know I'm picky like that.
No. That's, it perhaps is the advocate's general reluctance to concede, but always admitting what is and what is not. But we do very clearly challenge the validity and the legality of the ABCC decision, particularly in that we argue strongly it fails to meet the statutory standards of a decision that can be upheld by the courts, given the standards set forth in Chapter 30A, Section 11H. Specifically, their obligation to make a written determination of every question of fact and every issue of law necessary to the decision.
Chapter 138, Section 67 says,
yes,
if the commission approves the action of local licensing authorities, it shall issue notice to them to that effect. But If the Commission disapproves of their action, it shall issue a decision in writing advising said local authorities of the reason why it does not approve. It seems to say that the board only needs to give written reasons when it's overturning the locality and not when it's affirming.
I understand the court's question. It certainly has been advanced by the ABCC or the Attorney General, and so I'm not prepared to address the question at length. However, I would commend to the court's attention to review the legislative history. Chapter 138 has been around since 1933. I dare say this particular language in Section 67, the appellate administrative jurisdiction of the ABCC, has remained essentially unchanged, I would expect my research to show, since it was first enacted in 1933, strike that. I would suggest that Chapter 38 is a fairly modern invention that was created by the legislature sometime in the 70s, if memory serves me correctly. And again, I haven't done the research, so I'm going just by pure memory. And so 30A, I suggest, was a specific act of the legislature to establish more finite, very clear, very specific standards for administrative agencies.
It says, unless the general laws provide the agent need not prepare such statement.
I didn't hear the second part,
Chapter
Your Honor.
30A, Section 11 says you have to issue a statement of reasons unless the general laws provide the agency need not prepare such statement. So why doesn't that bring us into the statute which says an affirmance doesn't require a statement at all?
Because it's very clear that there is a litany of disputed facts that the ABCC ignored and failed to address, particularly as those were clearly presented in the record evidence, the exhibits provided at the hearing before the ABCC by the port. One example stands out in specific. One of the allegations of the violations of the conditions imposed by the regulations established by the Department of Public Health pursuant to the governor's executive order was that patrons at the time in question could not stand and consume an alcoholic beverage. There was very specific testimony, very specific evidence that alleged it was a particular brand of malt beverage.
How do we know any of this without a transcript of the hearing?
Well, because you have the record evidence and the documents in which the port put forth a statement from the wholesaler who sells the brand that was alleged to have been involved, and they didn't sell the brand in that container to the port. And as the ABCC knows,
I may be missing the point. Your point is people brought it in? Is that the inference that we're supposed to draw?
No, actually, the point is it wasn't an alcoholic beverage. The port did not deny that they sold root beer in a similarly styled bottle, but it's not an alcoholic beverage. And it was a disputed fact that you didn't even know exist when you read the decision of the ABCC.
But how are we supposed to know that is a disputed fact without a transcript of the facts that were presented to the board? I don't know that someone said, oh, I saw what could have been a root beer bottle or could have been something else, because I don't have a transcript.
Because you have the record evidence, the exhibits put in front of the evidence by the port before the ABCC, coupled with the closing memorandum of the port submitted to the ABCC with their permission, and it's very clear that that was a disputed issue of fact. So a transcript was not necessary, I respectfully suggest, to preserve that issue and present it here before this court as well as before the Superior Court. But the ABCC, contrary to their statutory duty, ignored it. If I'm, and you follow on that, or may I go back?
The time is yours.
Oh, okay. So, as we've gotten into it a little bit, the case today requires us to go back 5 years to those dark days of the COVID-19 public health emergency that began in March of 2020 when Governor Baker exercised his authority to declare a public health emergency and therefore impose otherwise non-existent legal restrictions on the freedoms and business operations of otherwise lawful, legitimate persons.
So if
like
they're legal
the port.
restrictions, why are they not right to say, well, it's a violation of the law? If they're
Well, because when you read the executive orders, and I recognize the ABCC has a litany of various executive orders that they review in their brief, but they do not tell the court the controlling one. Every executive...
Okay, go ahead. No, go ahead. Yep.
Every executive order signed by the governor from March of 2020 through up until August of 2020 had not only what this authority for establishing the regulations and standards would be through the State Department of Public Health, but it also had very specific language vesting particular agencies with enforcement authority for violation of those with those new regulations established only by the authority given under the executive order. We should be clear that none of the performance standards, the compliance standards, for which the port was prosecuted by the Howard Board of Selectmen, acting as the local licensing authority under Chapter 138, or the ABCC. None of those appear in the Liquor Control Act in Chapter 138. They don't exist today. None of them appear in the ABCC regulations, who has broad sweeping authority.
Then who would have authority to enforce the governor's emergency COVID-19 orders?
The governor said very specifically who had that authority. And each repeatedly in the executive orders signed by the governor and issued between March of 2020 and up until August the 4th, I believe, of 2020, through Executive Order number 46, the governor said for that 6-month period, enforcement shall be made by the State Department of Public Health and the municipal public health officials. Those are my words, not the
So
land.
it also says you have a civil fine of $300 pursuant to GL Chapter 277, Section 70C. Wouldn't that require, say, an ADA to be involved, prosecutor? At
To
some
the
point?
extent, yes, to the extent that criminal enforcement was the venue for that, but that's not this
But you're
case.
you're
This is
saying, what you're trying to say, I think, that only the Board of Health can, or DLS or DPH can enforce this. So wouldn't that mean that a prosecutor couldn't enforce this?
Well, that's not a legal issue pertinent in this case because we have no action by the district attorney whatsoever under 277.
But I don't, it seems to me, I don't, well, explain to me why your argument doesn't require us to go there as well. If you're saying that this affirmatively prevents the ABCC from doing anything about this, why wouldn't it affirmatively prevent an assistant district attorney or an assistant attorney general from doing this?
Well, for two reasons. One, it is enforcement through a different process, not the administrative process with sanction on the license. It is through criminal prosecution of perhaps the individuals involved. Number two is that when you look at the Executive Order number 46, at long last, the governor said, in addition to the State Department of Public Health and the municipal public health officials, there it is. The ABCC and the municipal local licensing authorities under Chapter 138 also can enforce violations.
This record suggests that there was no enforcement taken until after the governor gave the ABCC the authority. Well, it seems like it wasn't until December that there was a hearing at Harwich, never mind the ABCC.
The salient dates are the dates of the alleged violations, which occurred on three dates, one in May of 2020 and the other in 2 dates in July of 2020. And that leads into another issue that I'll resume.
Why is that?
Because
if starting in August, the ABCC has authority to enforce this, and it doesn't enforce it until after August, why does it matter when the violation happened, as long as the enforcement happens once they're given authority by the governor?
Because the authorities can only be available on a prospective, future-looking basis for conduct that occurs on or after the vesting of jurisdiction in the ABCC and the local licensing boards. Otherwise, it's an unlawful ex post facto law.
When the jurisdiction of the housing court was increased, did that mean it couldn't deal with leases that were signed before the jurisdiction of the housing court was increased?
I have no working familiarity with that today. However, I am familiar that Chapter 138 has been adjudicated to be a penal statute under Chapter 138, Section 2, that provides the general policy in Massachusetts that no person shall engage in any one of 8 activities except as authorized by the chapter. There are criminal penalties, a year in the house or a $1,000 fine.
Well,
further, Section 62.
How about when the juvenile court jurisdiction was extended to 18? Did that have to go backwards in time? Juveniles couldn't be prosecuted at all for crimes that were committed during that time? Why does the court that has to adjudicate something have to have jurisdiction on the day that the event happened rather than the day that they enforce?
Otherwise, it is an ex post facto law, I suggest.
Why? Ex post facto is usually when you make something criminal that wasn't criminal at the time that it happened. Nothing about how it's prosecuted.
The documentary record of this case shows very clearly why, and that is that each one of these violations was brought to the attention of the municipal health director in the town of Harwich. She noted it, engaged in communication.
Where's that?
That's in the administrative record, and indeed the appellant's brief has a recitation of the number of different communications with citations to the
Do you have a
record.
record site for that, though? Just
Yes.
the administrative record is large.
Oh, I'm sorry, yes, the record appendix, I misspoke.
What page? Is it
And-
record 1 or 2?
If I may.
B2.
So the redacted record is RA2.
I beg your pardon. Certainly, in the appellant's brief, there is some in the page. There is a recitation with citations to the record appendix. I believe it's record appendix number 2.
I think we're going to actually have to leave it there, counsel, as your time has expired. Let me just see. Judge Brennan has a question for you.
So do I understand your point on the?
Oh, it is there. It's in the agreed fact. I'm sorry.
No, that's okay.
It's in the agreed facts.
Do I understand your point, to be on the later jurisdiction, if you will, of the ABCC, that as between the Board of Health and the Alcohol Beverage Commission, there's different penalty structure for violations, or is that totally irrelevant and I'm missing the point?
No, that is one of the differences with the legal distinction under the governor's executive order from March till August.
Saying that initially the governor says, okay, this behavior is forbidden, and if you violate this, then the Board of Health will investigate, and there may be ramifications that can be enforced by the Board of Health. And then later, the governor says, oh, now the Alcohol Beverage Commission does, and they can enforce it, and there are a different set of penalties that they can enforce.
Yes.
Okay.
The jurisdiction of the ABCC and the local board under Chapter 138 is administrative sanction and a license, which can be suspension, cancellation, modification, revocation.
Which the Board of Health can do.
I'm sorry?
Well, I guess can the Board of Health do the same thing?
They would have to pursue the separate remedies under the governor's executive order.
Okay.
Thank you. Mr. Tretyakov.
Good afternoon.
Good afternoon.
Good afternoon, Madam Chief Justice and members of the panel. May it please the Court. Konstantin Tretyakov, Assistant Attorney General on behalf of the Alcoholic Beverages Control Commission, and with me today is Attorney Jeffrey Blake, who is representing the members of the local licensing authority. He is not making an oral argument today. The 3-day suspension of the appellant's license in this case was not an enforcement of the governor's executive orders containing COVID restrictions. It was the enforcement of the provisions of the Liquor Control Act, specifically set forth in General Laws, Chapter 138, Section 64, that says a modification, suspension, or revocation of license can be appropriate if a licensee permits a violation of, quote, any law of the Commonwealth.
And is the executive order the law of the Commonwealth?
Yes, that is correct. And under the aristocratic case that we cited to in our brief, it's plain that the definition of illegality, the terms that the regulation enacted by the Commission in this case, enacted by the Commission uses, and illegality would plainly encompass a violation of COVID restrictions. This court and the SJC and the Commission itself, it's entirely, from that perspective, this is an entirely unremarkable case. For example, the RK&E decision of this court decided back in 2020, the license was suspended for illegal gambling. There was no suggestion that by suspending license, the Commission was enforcing the anti-gambling laws. In the DeMello case, when the license was revoked for the sales of illegal controlled substances on the premises, again, there was no suggestion that the Commission was, by doing that, enforcing the Massachusetts Controlled Substances Act. So the same logic fully applies here. And the executive orders actually do have their own enforcement mechanism specifically provided in them. For example, in record appendix on pages, volume 2, on pages 176, 187, they say that the enforcement mechanism is a civil fine, a civil injunction, presumably pursued in the Superior Court, or a criminal prosecution. The Commission did not do any of that here. Instead, it...
And how would that criminal prosecution happen? The AG's office? How would the criminal prosecution happen? The AG's office would bring a complaint?
I would loathe to speculate about that, Your Honor. Conceivably, it could be either the District Attorney's Office or the Attorney General's Office, but that is, there is no indication, but it would definitely not be the Commission who would be bringing a criminal complaint. I think that's, that is safe to say.
So part of the reason I ask is because we have this argument from Mr. Kelly that there were these duplicative investigations through the ABCC and then through the police department. So could you speak to that briefly?
Certainly, Your Honor. The argument about the duplicative investigation at the outset, admittedly, is very hard to understand. So the first investigation that occurred was done by a police officer of the Harwich Police Department, and his report is found on page 261 of volume 2 of the record appendix. There is no indication in that report that the officer was acting as an agent or at the behest of the local licensing board. By all accounts, he says that in the report, I received a dispatch about the complaint, people drinking beverages at the premises of this restaurant, so he went there. So from the get-go, this...
And that's the one where he goes, he makes some observations, he goes and talks to management, and management says these are to-go beverages that people are receiving as part of their takeout order. Is that the police activity at that point?
That was what he uncovered during his investigation on May 20th. Then almost 2 months later, in July of the same year, July 16th and 17th, entirely different regulatory landscape. Additional executive orders were issued. At that time, 3 investigators of the ABCC come to the premises, and they observe different violations. For example, the police officer in his report was concerned about individuals without masks, individuals consuming beverages on the premises, as Your Honor has noted. Whereas the investigators were concerned about there are people sitting at the bar area of the restaurant. At that point, the regulations prohibited them from doing that, or there were more than 6 individuals seated at the same table. So it was a
But what if instead of 2 months later, on the day after the police make their observations, the ABCC goes out and makes the observations? Is that a duplicative investigation?
Your Honor, that is not obviously a factual scenario that is present.
Right, it's a hypothetical.
It's a hypothetical scenario. In this case, if they are, the statute in any of these cases.
Maybe I'll ask it in a better way. Maybe that was just a bad question. What is the meaning? What is, under Chapter 138, a duplicative investigation?
Your Honor, the statute does not provide for the definition of what duplicative investigation is. It does say in Section 23 of the Liquor Control Act that the Commission shall endeavor to not engage in investigations duplicative of the local licensing authorities. Here again, the initial investigation was not done by a local licensing authority. It was done by the police department. Yep. The investigations were 2 months away, and then the endeavor language is permissive. It's not mandatory. Unless...
So, okay, I'm sorry. Finish your answer, I apologize.
I was just going to say, unless there are any further questions,
I do have a question.
I will move to another point in my...
So why is it not inherently harmful to the port that the ABCC delayed for, I think, over a year before issuing its decision?
Your Honor,
It
because...
says 30 days in the statute.
Thank you, Your Honor. So the suspension here that was imposed is a suspension for 3 days. And it's not as if, because of the delay of the decision, 3 days become 5 days. So there is no, there is no interest, so to speak.
But they point out, depending on when those 3 days hit, it makes an enormous difference. It makes a difference to the owners, it makes a difference to the managers, certainly makes a difference to the college kids who are there trying to get some tips, I would think, during the summer. As opposed to in the dead of winter, when there's probably 10 people in the town.
Your Honor, in this case, I do not believe that the port has presented squarely that argument in that way in the Superior Court as to the specific timing. But then again, the suspension here was for 3 days of violations that occurred on the premises. And when that suspension is going to be enforced, depending on well, the Commission obviously affirmed the decision of the Board, so the suspension is going to be enforced at some point. And but more broadly, the sort of statutory, from the statutory perspective, they put a lot of emphasis on the fact that the decision must be issued within 30 days, but under the Amherst-Pelham line of cases, it's a directory, not a mandatory language. And again...
That case dealt with a regulatory requirement, not a statutory requirement, right?
Yes, Your Honor, but I think
Any distinction there? Why is it distinguishable in any way?
I think it is sufficiently analogous here because, for example, we do have some statutes, for example, if the statute, for example, would say the decision has to be issued within 30 days, otherwise the decision of the lower administrative agency shall be deemed affirmed. That would be a different story. But the Liquor Control Act does not contain that decision. And merely...
Are you saying the Board can just ignore the plain language of the statute and just issue a decision whenever they see fit, whenever it's convenient for them?
I do not believe... I would agree, Your Honor, that it is unfortunate that the Commission did not put into the decision the reasoning why the decision was issued after such a lengthy period of time, which
I mean, 30 days, it's not like it's 35 days. It's 400, I don't remember, it's somewhere between 300 and 400 days later, right? Somewhere around there?
Yes, Your Honor, that math appears correct to me. We do not know the cause of the delay from the administrative record, but again, it's a suspension of the license for 3 days based on violations of law that have been occurring over the course of 3 days. And when exactly the plaintiff does not get, the appellant does not get to choose when those restrictions, when that suspension of license is going to be applied. So on that prong, I don't think they can really establish prejudice from the decision.
Can you help me out with something? Your friend suggests that the August governor's order is important, but it's not in the record, and I had a real hard time finding it. Could you find it for us and just send it to us, either of you?
Yes, Your Honor. We would be happy to do that. I have read the relevant language of the order, and I don't think it is in any way dispositive in this case, because again, here the enforcement of it was the enforcement that is specifically set forth in the Liquor Control Act. The fact that the government saw fit in his executive order number 46 to mention the Alcoholic Beverages Control Commission, it did not vest the commission with the authority. It merely acknowledged what the commission has possessed and has had in its possession in terms of the authority for a very long time. So it was not establishing the authority, it was merely acknowledging it. But again,
I hear you, but I'd like to look at it myself. If
We'll be
you
happy
two
to.
could coordinate getting us that'd be great.
Unless the court has further questions, I will rest on my brief.
I don't see any others. Thank you very much. That was a very interesting case. It is under advisement. That concludes today's session of the Appeals Court. I would like to thank my Chief Court Officer, our wonderful timekeeper, our clerk's office, and our court staff. We are in recess. Have a good day, everyone.